In our media briefing series. My name is Glenn Lammi. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation's work, we are in our 38th year of public interest law policy advocacy. We try to do three things very well here. We started out as a litigating organization, filing briefs in all levels of federal and state courts, some original litigation, amicus litigation primarily, and filing of comments with regulatory agencies as well. Our publishing side, the Legal Studies Division that I serve as Chief Counsel of, is our educational side. We're sort of different from a traditional think tank in the sense that we recruit experts in law firms, in academia, in corporate counsel offices to write publications for us. We publish them in a wide variety of formats and a very wide range of issues as well. And then our communications side is responsible for programs such as this one. We also do web-only programs, as well as maintaining a blog called the WLF Legal Pulse. And I encourage those of you who are joining us online today to spend a little bit of time on our website after the program has finished up. This afternoon's program is kind of the third in a series that WLF has done centered around patent licensing and litigation by so-called non-practicing entities. Our first two programs focused on the consumer protection and competition policy concerns surrounding such activities and the efficacy of government investigation and potential action to address those concerns. One federal agency's role went from potential to actual last Thursday with the Federal Trade Commission and a notorious Assertion entity entering into a consent decree settling charges of unfair and deceptive business practices, and also the results of last Tuesday's election have rekindled hope of federal legislative measures to curb abusive patent suits. But as WLF has preached time and again over our nearly 38 years of public interest advocacy, waiting for or relying upon government to act are rarely the right solutions and certainly never the only ones. Some businesses faced with distracting or destructive patent licensing demands or lawsuits understand this as well. And in the spirit of their own technological innovation, these companies have devised dynamic private ordering approaches aimed at deterring and diffusing legal risk. We're honored to have three innovators in that area with us today, two of whom are chief executive officers of their enterprises, and one of whom acts as a director of a third. I will introduce them in the order in which they will make their presentations. Kevin Jakel is the Chief Executive Officer of Unified Patents. Mr. Jakel previously served as Intuit's head of IP litigation prior to being with Intuit, where he was a patent litigator with Kay Scholler and the late Howry LLP, where he represented clients in various technology areas. Mr. Jakel began his career as a patent examiner at the U.S. Patent and Trademark Office. Speaking second today will be Keith Bergelt, who is the Chief Executive Officer of the Open Invention Network, OIN. Prior to joining the OIN, Mr. Bergelt served as President and CEO of two hedge funds, Paradox Capital and IPI. Previously, he served as Senior Advisor to the Technology Investment Division at Texas Pacific Group. Finishing up today will be Tim Kowalski, who is Senior Patent Counsel at Google, a position he has occupied since September 2012. Prior to joining Google, Mr. Kowalski was lead intellectual property counsel for Motorola and Motorola Mobility from 2004 to 2012. He began his legal career as an associate in private practice, and he serves as a director of the License on Transfer Network Incorporated, which he will discuss at some point today. Kevin's going to lead off, actually, and set out the broader context of why these private ordering solutions are needed and how they sort of emerged, and then he will return to speak directly about Unified Patents' approach after Keith and Tim have had their chance. We're going to be using a PowerPoint presentation today. We have the printed versions for those who are here with us in person, and then online you will see the slides show in the box next to the video screen that you're going to be with. We'll also take questions from those in the audience here and also online. If you're joining us online, it's interactive@wlf.org is the address. You can get us started, Kevin.
Hi, thank you very much. I really appreciate the invite. Happy to be here and speak with everyone today. As Glenn mentioned, I'm going to do a little bit of two roles today. First, give a little bit of an introduction on the patent landscape and how we got where we are today. And then I'll come back at the end and talk a little bit about Unified and what we're doing in our part of combating NPE activity. In my discussion of the introduction, however, I'm not going to focus entirely on NPEs. Part of what this panel is about is kind of market-based solutions to combat patent and IP risk generally. And so we're going to talk about a little the general problems that IP professionals face generally, and then some of the solutions that have come up about that, how you handle those IP risks, talk about some of the entities that have developed over time with respect to the use of patents and their enforcement, and then finally maybe a little bit of an introduction of the different organizations that have developed over time to kind of combat the enforcement of IP. The first thing that maybe we'll talk about is the role of IP managers and professionals and operating companies dealing with patent issues. And that has to do with the difficulty that they have in dealing with the enforcement of patents across the board. Patent quality is probably one of the main issues that I see and I think others look at in terms of trying to address the overall enforcement of patent, trying to figure out whether or not the patents that are being enforced against you are really valid or not. In many cases, once that a challenge has been made to a patent, it's often the case that those patents end up being invalid. We saw that in a previous set of statistics at in the inter-parties re-examination, and after the AIA, we still have seen that the patents that get challenged are often found to be invalid. So trying to figure out what patents actually deal with, whether or not to take a license as an IP professional, or whether or not to actually try and fight, is something that's actually a very difficult job to do as an IP manager inside an operating company. Another aspect of dealing with this is just the IP risk generally. Operating companies are dealing with software, they're dealing with open source and different types of solutions, and how you deal with those actually is a very difficult thing for companies to figure out, license, enforce. To operate in that landscape is in many ways very complicated. The next part of in-house solutions that have really been kind of problematic have been dealing with NPEs and the enforcement of them. Partly that's because of the imbalance of power when NPEs assert patents against operating companies. In district court, operating companies that sue another operating company often have the ability to countersue. That countersue allows for basically a checks and balance. That means that operating companies are not likely to sue other operating companies without the ability to sue back. And that's not really the case when you're dealing with NPEs. Because of that, NPEs have really had an advantage when it comes to district court. And obviously that's been exploited over time, and that's kind of what we're dealing with here when it comes to NPE activity growing over the last 10 years. Taking a look at slide 5, what I've done is kind of put together a timeline. And at the bottom, we can see the offensive entities that have kind of grown up around patent enforcement, as well as on the top, you can see defensive entities that have come about. Back in 2000 to 2003, we really had 3 entities that came about that really did a lot to define the offensive entities that have been enforcing patents over time. Intellectual Ventures, IPNAV, and Acacia. All 3 of which have played a major role and are, I would say, pretty notorious in the field of patent enforcement with respect to NPE activity, and I would say that they're pretty much well known by most IP professionals out there. And many operating companies have dealt with those entities in one form or another. Going along, I also happen to hit Round Rock here because I think Round Rock and other institutions are examples of kind of a rise of what is sometimes referred to as privateering and the outsourcing of patent portfolios by operating companies that have non-core patent assets, meaning they're just companies have patent assets they're not necessarily using, and they can sell them on the open market, and then third parties can take those patent portfolios and then enforce them against others. Sometimes referred to privateering, but in many cases it is an example of how the enforcement of IP has been it basically turned into a capital chasing returns type of environment where companies look for the opportunity to outsource their patent enforcement. Investment is there in order to fund those litigations, and bring those litigations against operating companies in order to make a return on investment. There are many more additional entities that I would say exist on this side of the fence. Didn't include all of them. Obviously, patent trolls is a pejorative term that is sometimes thrown around for these entities, but in essence what we're talking about is a business model that has a wide range of different activities. In my world, we kind of group them all into one, call them NPEs, and we kind of work to combat that activity. On the other side of the fence, we have had a set of defensive entities that have come about over time to help operating companies really manage this risk, both from IP generally, how do you protect yourself and manage the operational risk of a patent that you don't own being used against you, and then more specifically, indeed, in combating NPE activity. We've had a number of operations that have come into existence to help companies manage that IP risk. The first one is Open Innovation Network. Keith's here to talk about Open Innovation Network. It's a great organization and has some really unique features that allow it to help companies mitigate risk, especially in the Linux field. Around 2008, there were two organizations that came into existence, RPX and AST, both of which have been primarily focused on the approach of buying patent assets off the secondary market or settling litigation on behalf of operating companies by paying trolls directly, or sorry, NPEs directly. And that activity is intended to try and get those patents out of the ecosystem before they become a large risk on behalf of the operational companies. Those entities, I think, are interesting in that they primarily transactional based and really focus on the purchase of patents or licenses in order to mitigate risk. Fast forward to 2012, Unified Patents was an entity that I formed back then to try and create a different way to deter NPE activity. And I'll go into more detail about exactly what we do later. But essentially, we're a defensive entity that does a little bit of the opposite. We are not transactional based, and we don't try to kind of buy our way out of the problem, either by buying patents or licenses in order to settle. The final defensive entity we have here that we'll talk about today is license on transfer. Tim's here to talk about that. Another great opportunity for operating companies to kind of band together and really work to create a solution in which operating companies can be assured that they're not going to be the victims of patents that are sold to third parties and NPEs, so long as those companies are participating. Tim will go through all the details around how law works and the advantages of it. One last thing I just wanted to say is that AIA came in 2012, and it really, I think, is in many ways a change in direction for NPEs. The use of post-grant procedures has been, I think, quite significant in the give and take of NPEs versus operating companies. And that's one example of, I think, where we've got really this cat and mouse game between operating companies and NPEs or patent enforcement that is really a cat and mouse struggle between greater freedom to operate and increased risk. And balancing those two, I think the AIA has played a significant role in giving operating companies something they can really use to balance the struggle between those two. I think there's at least one other thing, which is that these solutions are really market-based. And I think that it's a good opportunity for operating companies to embrace the market-based solutions in addition to legislative, judicial reform that's really, I think, gone a long way to balance the power between NPEs and operating companies, or balancing IP risk and operating companies generally. So with that, I think I will turn it over to Keith, and I'll be back later.
Thanks, Kevin, and it's a pleasure to be here. to talk about patent non-aggression. Quietly, OIN, Open Invention Network, has become the largest patent non-aggression community in the history of technology. These kinds of activities, per Kevin's timeline, are not terribly old. So the fact that we've been around since '05, and really one of the significant elements that OIN triggered when it emerged was the level of activity in the secondary market for patents. The Commerce One portfolio was the first patent portfolio to be made part of a pillar of what OIN possesses in its owned patent portfolio, which now totals well over 900 patents and applications globally. And that portfolio and the auction nature of the activity around it created a certain level of energy in the secondary market, which is sustained to this day, and brought many, many speculators into the community, financial services companies, hedge funds seeking to be able to acquire patents and create return. As Kevin indicated, there's a lot of energy around capital chasing spread. People are looking to put out money. There are entities that are funding litigation and have done so on a regular basis for the past several years, and more of them enter the market every month, it seems. I was just at an event in New York which focused solely on the financial services sector and activities related to patent monetization, and it was very well attended. OIN has now over 1,200 licensees. In fact, the number is about 1,290. We grew from a point where in early '05, in the wake of SCO litigation, which was litigation related to Unix patents that a operating company was funding, which was concerned about the rise of Linux. OIN was architected creatively by IBM and Red Hat, and joined by Sony, NEC, Philips, and the people from SUSE at Novell, which was another was another major platform to support the emerging, at that point, emerging space for enterprise Linux. And so with the OIN model, the intent was to create freedom of action and freedom to operate in Linux, and with it, take advantage of what was becoming and has continued to further develop into the core modality for invention and innovation. You look at major platforms like Android, which are Linux-based. Android was a small open source-based company built around the Linux kernel. Was brought in by Google, kept open, and has flourished to become the most popular operating system that supports mobility globally. And that model is used in the enterprise space. It's being used in the auto space, in the home, as well as in middleware, and in the cloud, with the emergence of new projects, open source projects like OpenStack, which is one of the most creative endeavors that any technology community has ever undertaken, second only to Linux in terms of the productivity in its brief time frame of existence. And so the OIN model, simply stated, is to essentially create, as you'll see on slide 6, it embodies the notion of co-opetition, which was first articulated in a scholarly journal in the Harvard Business Review in 1994 by a Harvard professor who talked about the whole notion of what the future means. And the future embodies the idea of cooperation and competition. And the cooperation or collaboration zone is the Linux system for OIN's purposes. And what we've done is simply say that companies that participate, that are going to benefit from collaboration and this modality that open source represents, where 1 + 1 + 1 doesn't equal 3, it equals 6 or 10 or 20, because we're distilling the collective intelligence of an entire community of technologists across the world to be able to advance these platforms and grow them. And so what we're doing is saying that the functionality that's core to the projects that support Linux, that are built on Linux, in these various arenas of mobility, virtualization, the cloud, the enterprise, etc., that this core functionality makes up the zone of non-aggression. And in that non-aggression zone, we agree that we will collaborate and share patents. So there's a cross-license obligation, and you agree also to forbear litigation in that zone. And so what OIN has done is essentially create a community of interest. More so than a license, it's creating community, recognizing that for the benefits that we get from open source in terms of innovation, there are also obligations. And OIN has grown into a very significant, and as I said, the largest patent non-aggression community in the world. But I think the point is that it's not the only solution. The gentlemen to my left and right are authoring solutions more recently that are highly complementary to what OIN is. OIN works within a zone and within an environment, and it is being replicated to support other open source projects as we speak, but there's still other issues that need to be addressed. And I'll turn it over now to Tim to be able to talk about the license on transfer program and give you a sense of how Google's authored something which is now being embraced by many companies to support the anti-privateering.
Thanks, Keith. It's my pleasure to introduce all of you to the LAP program this afternoon. The LAP program, starting on slide 7, as you can see, the LAP program is an independently run, community-based program designed to address the growing problems of patent privateering and patent assertions from patent assertion entities. Patent assertion entities, or PAEs, or NPEs, or trolls as we call them, as I think you know, are all companies that have a business model centered around extracting patent royalties from operating companies, but really don't do much of anything else. And so at a high level, the lot agreement is a multilateral springing license arrangement under which the members agree that when they transfer a patent outside the group, the licenses to other members become effective. And so in this way, the participants are protecting themselves from patent assertions under those patents if they're later sold to a PAE or just to another company. It inoculates the membership from those assertions. And so why are we doing this? Let's flip to slide 8, which shows litigation or patent litigation trend over the past several years. This is probably a phenomenon you're all familiar with, but patent litigation has really exploded over the past decade. In 2006, there was something on the order of 2,500 patent litigations. In 2012, it was nearly 5,000 cases. But what may not be quite as well understood is the percentage of these cases that are actually coming from PAEs or patent assertion entities. And so you go from about 20% of these cases in 2006 being patent assertion entity cases to about over 60%, I think it's 62% of them are patent assertion entity cases in 2012. And the trend, this slide's a little stale, but the trend continued in 2013 with roughly 5,400 patent cases being filed and just over 60% of those being patent assertion entity cases. And so that's one of the problems we're dealing with, and it's just as the trend on the chart shows, it's a bad problem and getting worse. The other thing we realized when we were as we were developing this idea was the realization as to the source of these patents that the patent assertion entities were asserting against operating companies, and where are these patents coming from? Well, they're coming from operating companies. The data shows that over 70% of these patents are coming from operating companies. So, in other words, the problem we looked at on the slide showing patent litigation and patent assertion entity litigation getting worse for operating companies is the result of operating companies really doing this to themselves to some extent, or at least a certain subset of operating companies doing this. And there are a number of reasons that operating companies may sell patents. They may do them. They may be sold in connection with a business going under and as part of the distribution of assets. Distressed companies may sell patents to get cash to make the numbers for a quarter. Changes in business models may exist such that A company may have patent portfolios that are no longer relevant to a particular product line that they have gotten rid of or are no longer developing, and so they decide to get rid of those excess patents. Or, as we talked about a little bit earlier in the program, companies may be outsourcing a licensing program. But at the end of the day, these patents are coming from operating companies to secure some sort of revenue base. But when you take a closer look at it, the economics really aren't compelling. The research shows that patent assertion entity cases cost operating companies about $30 billion annually, but less than 25% of the costs associated with those assertions are actually coming back to the companies that have sold the patents. But operating companies as a whole bear 100% of the cost. And so if you look at it another way, it's kind of like, I'm going to sell you my patent for 25 cents, and then I have to turn around and pay you $1 to use it. And so that's a bad deal for everyone involved from my perspective. Looking at it another way, looking at the economics another way, when you can compare the cost of patent litigation versus the revenue generated from patent sales, the data shows that the average patent family transacts for about $250,000. And you contrast that to the cost of patent litigation, and there are varying costs for the size of cases, but most of the cases have been, in my experience, the amount in controversy has exceeded about $25 million because these are big companies that I've been involved with, and the average cost of defense for a litigation where the amount in controversy exceeds $25 million is about $6 million. And so you look at the cost to defend a case, $6 million, versus the cost of a patent sale, $250,000. Again, the economics aren't compelling. And then just a comment about small companies. I think it was last year, over 50% of the patent assertion entity assertions were against small companies having annual revenues of less than $10 million. And so you can quickly see that it's particularly devastating to small companies that earn less than $10 million a year to have to pony up for these patent cases, these costs of defenses that are $6 million per case. And then this problem, it just isn't a big company problem or a small company problem, and it's not just a high-tech problem either. Last year, the cases against what are traditionally thought of as non-tech companies, retailers, automotive, financial services, consumer products, the cases against those industries exceeded the tech companies. So a lot of cases against a lot of companies, big companies, small companies, high-tech, non-tech. And what's an operating company to do? There's the fight model. There's the pay model. Sometimes it's a fight and then pay model. But all this seems to be the vicious cycle that hasn't squashed the problem or hasn't reduced the problem for these operating companies. Rather, as we can see from the slide, the trend is going in the wrong direction. And then what else could an operating company do? Well, this patent reform has been talked about, but it doesn't appear to be headed anywhere anytime soon. So we proposed the lot program or the lot network, the lot agreement. We call it all these things as a solution. And again, under the terms of the lot agreement, lot members agree in advance to grant each other licenses that become effective when they transfer patents. And we'll talk about it visually here. If you flip to slide 9. This is an illustration of the lot agreement's operation. And at time 1, in the upper left, there are two companies, or there's companies 1, company 2, and then companies N in the lot program. At time 2, company 2 sells a patent to company 3. Company 3 is outside the lot network. Immediately prior to that sale, under the lot agreement, licenses to the other lot members become effective such that the other companies, company 1 and companies N, have a license under that patent that was sold to company 3, and these licenses are represented by the solid arrows. Thus, if company 3 is a patent assertion entity, or if company 3 sues the other members, company 1 and company N, or later sells the patent to a company that is interested in monetizing that patent and suing the other members of the agreement. Those members are have licenses under that patent and are otherwise protected from suits from Company 3 or a subsequent transferee. So that's the operation of the lot agreement in a nutshell. There's just a few other high-level terms I'll touch on briefly. Membership versus membership. The lot agreement is open to anyone, and we'll get into the current membership in a few minutes, but big company, small company, large patent holder, no patents, anyone can join the program. All the members are listed on the lot network's website with their dates they've joined the program, dates that we've withdrawal, so participants can quickly get to the bottom of whether a particular patent they're interested is subject to the terms of the agreement. Withdrawal, once a company, withdrawal is another term I'll hit on. Companies can withdraw from the program at any time on 6 months' notice, but the obligations with respect to a withdrawing company's patents that it owns at the time of withdrawal continue to be, those patents continue to be subject to the obligations of the agreement. And so, for example, if a company withdraws and later sells a patent it owned at the time of withdrawal, that patent is subject to becoming effective under the terms of the lot agreement. But if a company after it withdraws later acquires a patent, that patent is is not subject to the lot agreement. Assignment, the third high-level term I'll touch on is assignment and change of control. There are very detailed provisions in the agreement that touch on assignment and change of control, and I won't get into them here. I'll just say that they're, the agreement's designed to be M&A neutral, and the provisions are consistent with traditional cross-licensing frameworks that many of you are familiar with. And then finally, with respect to the high-level terms, there are some value-preserving provisions I'd like to touch on. First is that there's no trigger for the licenses when the patents are transferred. When the transfer occurs in connection with a certain M&A activity or certain check transfer activity. So, for example, if I'm a lot member and I sell off a business to a third party, the patents that relate to that business don't trigger. However, just like we talked about when someone withdraws, they're subject to the ongoing obligations of the agreement. Sales within the lot membership also don't trigger the licenses. So in the example that I believe you still have in front of you with the illustration of the program, if Company 1 sells to Company 2 or vice versa, there isn't a trigger at that point in time because the patent is still is within the lot agreement. It's owned by a company that is subject to the terms of the lot agreement, so there's not a trigger at that point in time. And then finally, the third value-preserving provision that is in the agreement is defense of suspension by a non-assertion transferee. And so, using the companies 1, 2, and 3 in the graphic in front of you, if Company 2 sells to Company 3, and then Company 3 is later sued by Company 1, Company 3 can, it's a little hard to follow, I understand. Company 3 can suspend the licenses to under the patent to Company 1, and therefore they can use that patent to defend themselves from the attack from Company 1. And so this preserves value. You can sell the patents for defensive value, and it also helps build this culture of non-aggression that we're talking about today. Again, those are the high-level terms. I touched on those quickly, and I'll point you to the website at the end that'll have a lot more detail that you can go to. A couple comments about status. We launched the lot program in July of 2014, and at launch, the members were Asana, Canon, Dropbox, Google, Newegg, and SAP. At launch, we had a ton of great press that was, I would say, was overwhelmingly positive. We have links to a lot of those stories on our website if you're interested, and you can check those out there. The momentum has continued since launch. We've added Pure Storage, SAS, Red Hat, and GitHub. This brings the total membership to 10 companies, and with those 10 companies, there are nearly 300,000 patent assets that are covered by the lot agreement, including over 50,000 issued U.S. patents are covered by the agreement. So we think it provides, it certainly provides a lot of value at scale and over time, but we think that this membership and these number of this quantity of patents under our belt, it provides immediate value today. As I touched on a little bit earlier, our membership, I think, demonstrates the one-size-fits-all nature of the lot program. We have a Japanese company, European company, U.S. companies, established companies, startups, upstarts that are members, and we think that represents and shows that the lot program is a good deal for companies, no matter what your operating companies, no matter what your situation is in terms of your life cycle. What are we doing next? We're working on scaling the program and are actively recruiting new members. So why would a company want to join the lot program? Quickly, there are a number of advantages, or a lot of advantages, as I say on slide 10. First of all, we think that the lot program will reduce the instances of PAE assertions against its membership over time. Second, the lot membership will increase freedom of action for the member companies as members sell off patents. Those companies get royalty-free licenses to those patents that are sold. It harnesses the network effect, so as membership grows, the protection quickly scales at a much faster pace than one can achieve with traditional bilateral cross-licensing efforts. Fourth, and this is an important one. Well, they're all important, but this is one that's not so obvious that I'd like to touch on for a moment. Is it unlocks the dormant value in your portfolio. So by joining the program today, you can get freedom of action under nearly 300,000 patent assets, as I indicated before. Otherwise, whereas a lot of companies aren't selling their patents and they're not doing anything with their patents. This unlocks the dormant value in them. And to the extent that there's any perceived diminishment in value in terms of joining the program, I would just say that this is immediate value today versus the theoretical risk that you may want to sell a patent down the road, and the theoretical risk that the lot encumbrance will somehow diminish the value of the portfolio. And then finally, and most importantly, this isn't a traditional cross-license between companies, and so this doesn't interfere with what I consider to be legitimate uses of patents between companies. So competitors can still sue their competitor if they think they want to protect their product space. They can still license their competitors. This is really targeted at getting at the problem of PAE assertions where patents are coming from still operating companies. So in conclusion, I would say that the lot program, we believe the lot program will, with time and at scale, really work to reduce the instances of patent assertion entity litigation against its membership. It's a self-help approach that companies can execute today. For more information on the lot program, you can check out our website at lotnet.com, LOTNET.com. There's a copy of the lot agreement on the website there. You can download it, take a look at it. There are a number of FAQs and explanations of the program, as well as a couple overview presentations that go in a fair amount of detail as to how the program works. So thank you. I'll turn it over back to Kevin.
All right, so I'm back and going to talk about unified patents, and I'm excited to do so because I think unified patents is really a unique, interesting approach. Allows operating companies to do something that's proactive and never really been done before. I'm going to refer a little bit to slide 12 and talk real quickly about what I see as kind of a vicious cycle of NPE litigation. And I think it's really important to understand some of the incentives that are involved and why NPE activity has been particularly advantageous, and why I think it has really flourished under the current set of legal structure and judicial structure that we've had in the district court legal system. So when it comes to defending against an NPE litigation, one of the things I had mentioned in the beginning was kind of an imbalance of power. The fact that you really don't have the opportunity to countersue an NPE, which is very different from a litigation that would be brought by another operating company. In-house folks really have a large amount of uncertainty in dealing with an NPE. In many cases, as many of you might know, the amount that an NPE is asking for can often be less than the cost of actually fighting the litigation. That's not to say that the infringement is not necessarily legitimate. The infringement can be valid. It's just very, very difficult for a company and in-house counsel to figure out whether or not that litigation is one that they should take a license to or fight. And that has really caused many companies to fight for a little bit, evaluate the likelihood of settle, and then fight the long run and have like liability in the end, large damage award, unknown legal fees. All this uncertainty often means that companies choose to settle rather than fight. Statistically speaking, 50% of all the companies involved in NPE litigation settle within the first 6 months. For those litigators out there, most of you know nothing really happens in a litigation in the first 6 months. So nothing is really being decided on the merits. That basically comes back and incentivizes an NPE to go buy another patent and do the whole thing over again. Or other NPEs or others watching this development are incentivized to do this themselves, and they go and create copycat NPEs. And so we have a group of companies, a business model that has developed over time that's really created this vicious cycle. That is, in the diagram you can see patents kind of being pushed over the top toward a group of companies. Many of them settle, money is then returned to the NPE community, and it starts all over again. The question is, how do we try to do something to either slow that down or stop it? My personal view of it is that there are entities out there that try and settle these litigations on behalf of companies. That increased capital put into this model actually only speeds this whole vicious cycle up. Increased capital into the market ends up speeding the whole thing up. That's the way we kind of look at the economics of this. And so what we've tried to do, and in my role as in-house and outside counsel, I've kind of tried to figure out what can we do to change the incentives. How do you do something to change the economics of an NPE assertion model? And I think really it needs to be a proactive solution. Unfortunately, as litigators and many in-house counsel will also know, being proactive when it comes to patents is incredibly difficult. No one wants to be put on notice. No one wants damages to start ticking. There's a whole bunch of things, and as many of you also know, as a result, there's general policies in place that no one looks at patents, which, again, I'm not saying that's right or wrong. In most of the NPEs would say that's part of the problem. Operating companies say we're just protecting ourselves from increased liability. The point is what we want is an opportunity to be proactive, and Unified is actually a creation that allows an outside entity to do work on behalf of a technology area, to be proactive on behalf of that technology area in a way that an operating company can't do it for themselves. So as you can kind of see in the diagram we have here, we try to break that cycle of litigation by taking a technology area and putting a protective kind of bubble around it. We want to create a deterrent around a technology area, so that technology area is essentially less likely to be targeted by NPEs than other technology areas. We are very pro-patents. We want companies to be able to use patents for their business goals. We want to kind of level the playing field between NPEs looking at a technology area and saying, I want to go after and try to monetize patents in that space. We want to be the protectors of that technology. So rather than going after the technology area we're protecting, might as well try and go after the house next door that's left its back door open. That's essentially the deterrent model that Unified is trying to create. How we do that is probably the big question that's out there. What we do is really group operating companies, both big and small, together. To Tim's point about this is not only a large company problem. There are both large and small companies that really form the basis of the defendants in the space. Now, It's also true, as Tim pointed out, that many of the companies that are in the space are the ones selling patents to NPEs or PEs that turn around and then are used against everyone else. So what we have done is basically in a technology area, partnered both big and small. So we take large companies to participate in the technology area, and they provide us funding in order to do the work that we do. Small companies who would never have any funding to do any work anyway, or actually provide us any money anyway, they get in for free, and in exchange they give us basically a notice provision related to their patent portfolio. And we pioneered this about a couple of years ago, which is those companies can join, and they have to basically tell us if they're going to sell to a patent enforcement entity in advance. And if they don't, everyone gets a license. What that does is put us in a position to really capture the knowledge about patents moving from the hands of operating companies, small and big for that matter, into the hands of an NPE that could then turn around and be used against the technology area we are trying to protect. It's incredibly important. It's a big part of what we are trying to do is create a technology area where the patents in that space are less likely to land up in the hands of an NPE or PAE. The operating companies that actually pay us, we use that revenue to then monitor the technology area we are protecting. We do that basically on 4 levels. We look for everything that's on the secondary market, monitor everything that's for sale. We look at it, figure out whether or not it's a risk to the space, and if it is, then we start looking to see whether or not it lands in the hands of an NPE. We basically also do patent analytics. We're looking to see every single patent that we can find in the space and find out who owns them. And if they're owned by NPEs, they go on the list for us to take additional looks at. The final 2 categories are demand letters. Many of you are probably aware of them. But we're looking to see if there are any demand letters that are active in the technology area we're protecting so we can go after and try to find those and figure out who's asserting patents against who. It's particularly important because small companies are often the recipient of demand letters, and so we want to be able to bring those small companies into our fold, get information from them that allows us to then protect the group as a whole. The final area is obviously litigation. We're looking to see who's suing who in our technology area. Once we know who they are, then we check to see if they're NPEs or not, and obviously if they are, then we're taking additional looks at those companies. The next step of what we do on behalf of the technology area is obviously the prior art and invalidity analysis. So one of the big uncertainties that's faced in the patent community is figuring out which patents are valid and which ones are not. And it's a complicated set of factors, but unfortunately a lot of the litigations, a lot of the patents used in litigation end up being invalid. It's just a fact, both in litigation and at the USPTO when patents are looked at for a second time. So what we want to do is make that an efficient process in which Unified can look at patents and filter them in the most effective and efficient way possible. When we do that, obviously we want to find patents that are in the hands of NPEs that we also think are invalid. When we have those, we independently make a decision of whether or not we want to go to the USPTO and challenge them using inter-parties review that came into effect after the AIA. We do that on behalf of the technology area, and we do it independently. So we don't have any communications with our members. None of our members know which one we're going to go after and which one we don't. We're kind of like an independent organization designed to protect that technology. So we do pick patents that we think are invalid and should never have been issued in the first place, and we go out and we file IPRs against them, and we challenge those patents so that they're not a risk to our technology area. And then we repeat and do this all over again. Collect small companies, get rights to their patent portfolios so that those patents are less likely to land in the hands of NPEs, gather members, do the work to make the technology area that we were protecting as unattractive to NPE activity as we possibly can, and hope that they go elsewhere. It is, in many ways, a market-based solution that is a do-it-yourself type of approach to being proactive, something that operating companies really can't do because of the structure of the current laws and the way in which liability attaches if you try to actually be proactive. So on slide 13, we have identified some of the technology areas that we're working in already. We have cloud storage, which was the first technology area we kind of got up and running. We've done dozens of prior art searches. We have dozens of companies, both big and small, that are participating. In particular, we have hundreds of patents that are underneath the agreement that allows for us to get prior notice if they're being sold to an NPE or not. And same thing, we have content delivery as another technology area we're protecting. Electronic payments and wireless are the technology areas that are currently up and running on our behalf, and we're doing work on behalf of operating companies to protect. We think it's particularly important for operating companies to take a proactive approach. One of the big complaints we see from NPEs is that operating companies are not doing freedom to operate searches. They're not trying to clear the products and services they're doing. Unfortunately, that is a reality of the legal system we live in. And Unified is a tool in which we can do something on behalf of a technology area. So the patents that actually do get used in that space, we're happy to see them so long as they're valid. So that we're, in some ways, we operate a little bit like a filter. That is, we want inside, let's just use cloud storage, we want companies to freely use their patents against each other if that's what if they need to do for their own business purposes. If you're an NPE in that space, that's okay too. But if you do use your patents in that space, you better be sure that the patent that you're using is of the highest quality. And that is, Unified's here to be a way in which we can help filter out the use of invalid and poorly crafted patents to basically fund that cycle of vicious NPE litigation. And so that's what we do. We think the advantages of having an operation which does that on behalf of those companies, increase freedom to operate in the space, increase access to patents and competition. We're particularly proud of the fact that we have basically a split membership of over 60 companies, everything from some of the biggest companies in the country all the way down to startups that make, in many cases, absolutely nothing. And so we're really working on behalf of both of them. We provide services to those small companies so those companies can come to Unified and say, hey, what's going on? How does this work? We've got a demand letter, or we're concerned about this. They can come to us and understand the landscape in which they're participating in, because in many cases, they won't have IP counsel. And in many cases, the only real patent exposure they'll have will be having been told that maybe they should file a patent application on their idea. And that's really not a good way to mitigate patent risk, because that's really protecting your products and services from being copied, but it really does nothing to protect your company from the inbound risk of patent assertions on the outside. So I think, the only other thing I would add is the focus here with Unified is that we are designed to deter rather than incentivize. And key to that, we think, is the fact that we do not pay NPEs anything ever. And so we're not, you can't negotiate with us. And so if you come into a field with an invalid patent, we're basically there to act as the filter in order to do that, allowing companies to hopefully look at, over the long run, a technology area which sees less and less and less NPE activity and greater and greater and greater freedom to operate in those spaces. So I think that's it.
Thank you very much. Before we get into questions, I want to see if Keith or Tim had anything to add from your colleagues' comments as you went along.
I think one important point as I'm listening to the presentations is that this is not where individual companies are paying tens of millions of dollars a year to participate. In fact, in the case of OIN, there's no obligation other than forbearance of the right to sue and the cross-license obligation. There is no money that changes hands. And we do a whole range of other things that are like pre-issuance submission came out of AIA. That's something that we're also supporting to be able to create more freedom of action to remove potentially damaging applications or scale back their claim scope. And I think the other programs are not These are not, you pay us $10 million and we may do some things for you, which you see other things that have come before or that are adjacent activities had different motivations and goals. These are specific, purpose-built programs designed to accomplish goals that are very tangible. And I think that's what I would take away if I'm sitting in your seat from what's been presented today. They are complementary, and they're complementary with some of the other things that are out there, but these three programs, we're not here by accident. These are three programs that have been well thought out, well designed, architected, and supported by dozens of large companies across the world. These are not localized North American, European. In fact, we have, of the 1,280 licensees, 58% of them are from Europe. So, Tim, did you have thoughts?
Yeah, there's a few specific comments to follow up in terms of the the complementary nature of the program. I think you can look at OIN's membership and the lot participation. You're going to see a lot of overlap between companies. Of course, we have a ways to go until we're at 1,200, but so check it down, check it again. But I think you'll continue to see overlap. And then on the fees with respect to lot, they're very low. There's a rate table published on the lot network's website, but they basically cap out at $20,000 per company per year, and those fees are, it's a nonprofit organization, and those fees are really to cover the administrative costs of running the website, running the program, and also paying for the lot administrator to do business development in terms of recruiting other companies, because as I talked about in my prepared remarks, the real value in the program is really at scale, and so it's a much bigger benefit when it's 1,000 members versus when it's 10 members, and so the portion of the fees is going to help fund that business development activity. That's it.
Well, and I would just say that all three of these programs, they're not designed to kind of feed the beast in a sense. That is, that we are not here to go out with patent purchasing programs that require significant amounts of capital in order to achieve that. They're all tailor-made in order to target a specific kind of activity or a specific kind of goal, and do so through creative legal frameworks that achieve that without large amounts of capital requirements. That I think is a unique and beneficial aspect of all three of the programs we're talking about today.
As I said at the outset, we're happy to take the questions of those of you who are online. Just email us at interactive@wlf.org, and I will direct the question to the speaker. Do any of our attendees in person have any questions for our speakers today? Yes, you're going to be handed a microphone, which is for the benefit of the online audience and will not elevate your voice.
Hi, I'm Michelle Lee, I'm with the App Developers Alliance, and I know that kind of the point was to talk about the market-based solutions, and I think everything you guys have said is really interesting, and I haven't heard of it before, so I really enjoyed presentations, but I'm wondering what you think the role of government is. I know we've heard about patent quality quite a bit, and that seems like something that is an inherent problem, the government, not funding the USPTO. So I'm wondering what you think the role is of government in this case, whether that's litigation, and if you have thoughts on it, what that legislation, what that legislation might look like. I've heard of like fee shifting and things like that.
I think, as Glenn mentioned earlier, to kind of start the session, that legislative reform, the second phase of American Invents Act 2, the Innovation Act, reborn, whatever we want to call it, I think we're headed in the right direction with some of the discussion that was had leading up to the point where it's been tabled. So I think regenerating that and keeping it focused on achieving the pro-innovation goals that it has, I think that's important. But whatever we do, we really have to meet whatever legislative reform, judicial reform, halfway. And I think a constituency like you have has a great opportunity to create statements of prior art through defensive publications to be able to meet the reciprocal obligations we all have to make sure that if we have tens of thousands of statements of prior art that come from the app developers, if they don't want patents, if they file publications, it will force the bar higher, because all of those statements of prior art will prevent other people from getting patents on those ideas. And that would be very useful, particularly as we've created a very dynamic, rich market for app development around multiple platforms. All the environments I mentioned are ones where we're seeing active app development. And so that's what we're trying to promote, is in the alternative to patenting. If somebody wants to patent, great. If they don't, let's make sure that we don't not leave a trace, because we need to leave a trace. And in fact, it's our obligation to leave a trace to ensure of our creativity, so that we don't have issues in the future like we've had in the past.
Or if you care to comment as well?
Well, I mean, I can say that I think that Keith is right. I think there is a significant need for partnership between operating companies with respect to judicial and legislative reform, and that the balancing act here is that all patent owners, for the most part, have an interest on both sides. That is, you want strong IP rights so that your patents are enforceable and can be used to protect your products and services. And you also want freedom to operate so that you're not subject to meritless patent litigation. And that balancing act is one that I think is not easy, but it's one that I think requires a partnership and between operating companies, the government, as well as I think there's a role to be played for third parties like ours up here, that we are a market-based solution that helps with managing some of the issues that are involved in this balancing act of which side does the pendulum swing on? Are we going to be pro-patent, or are we going to be, pro-operating company, freedom to operate? And where that pendulum ends up swinging and stopping, I think there's always the risk that we have unintended consequences from all kinds of activities, including third parties like our own.
Any further questions? Yes.
Yeah, Richard Samp, I'd like to ask a question about the ongoing FTC investigation. I'm wondering if any of you think that anything worthwhile will come out of that, and are your organizations cooperating with the FTC in gathering information about NPEs?
There's actually a parallel program in Europe that I'm participating in, coincidentally, that the European Commission has undertaken and has its culminating session the day before Thanksgiving. So I think we're supporting that. We've testified to the FTC before as well, trying to highlight what we think are areas of concern that are an anathema to innovation. And so I think we're always active in Washington with ITC. ITC reform is another area. So I think across the board, we've got the kinds of cases that we shouldn't have in the ITC, which create fear, uncertainty, and doubt, and damage the cost profiles of litigation as well. So I think across the board we have issues.
Were you referring to the FTC with MPHJ? So we are not working or providing information to the FTC, but with respect to the activity, large-scale use of demand letters and other type of techniques to try and drive the settlement or the resolution of these type of patent enforcements, Unified is very much trying to play a role in that. We want to bring small companies into the fold specifically for that they have resources to come to, and they can figure out how to defend themselves, what entities to go talk to, whether it's the government, whether or not it's the in-house or outside counsel, to manage that type of risk. I think that it's difficult to get a handle on just how much use of demand letters there is out there. And that is actually, I think, going to be long-term one of the big problems. And there have been some interesting efforts through the USPTO and others that I'd encourage everyone to look at and participate in order to really bring the amount of demand letters and other type of assertions into the light so that we can figure out exactly how big a problem it is, and then take action against those that we think are meritless or shouldn't be used.
Yeah, and I would just add, I mean, the Lot Network isn't participating in that study, and just in where, you know, the Lot Network, you know, it inserts itself in this cycle and this problem we talked about, whereas Unified is kind of when these letters have come, or when, you know, they're studying the area, when the letters have come, or when the assertions happen, or when the trolls start to disrupt a particular zone. The Lot Network, by design, is you know, way ahead of that issue in terms of the timeline. And so the Lot Network, you know, when effective, will actually work to, you know, grant its members licenses and thus reduce the number of envelopes that its members receive in the mail with these demand letters, because, you know, PAEs or whoever is eventually purchasing these patents will purchase them even knowing that the Lot Network membership is licensed under these patents, and so sending the letters isn't really of any value. Kevin, is the decision from the U.S. Supreme Court, the Alice Corporation decision, have you seen any direct impact on the inter partes review process there, the way the PTO is looking at patents the second time around? There's been some court decisions largely going against the viability of patents under that sort of framework that the court laid out. Have you seen something similar happening at the PTO?
Well, certainly in district court, we've seen an impact, and I agree there's been a number of district court litigations that have gone to invalidate a fair number of patents. With respect to actions taken before the PTAB, we have not seen a whole lot of impact from Alice specifically. I can say that I think there's a fair amount of belief in the secondary market that Alice is having a pretty dramatic impact on the sale of patents. That is, there's rumors out there that the secondary market and brokers and others engaged in the transaction of especially software patents, those patents have seen a reduction in either demand or price for those transactions to take place.
Yes.
Hi, I'm Michael Sartori from Venable. I'm the chair of the Patent Prosecution and Counseling Group. And you can look at the Supreme Court term as being an anti-patent troll cases that came out. And two of the cases had to do with attorney's fees and exceptional cases. And I think I've seen a number of cases over the summer and the fall where there's been more fees levied against, I think, NPEs or APEs. Do you think this is a blip on the radar or a trend that's like changed the equation for litigation for them?
Well, I would just briefly, I would say I do see a shift in you know, how these cases are decided, how these go, you know, both the district court and how, you know, obviously what the Supreme Court's doing in their, you know, continued interest with patent cases. And I do think it's you know, it's an interesting time to be a patent professional in terms of you know, licensing and litigation. You see where you know, on top of the fee shifting you mentioned, you see what happened to SEPs over the past several years, and so I see it as a continued trend, and you know, how far it'll go, you know, is to be determined. I think that it's early days, and there's a lot to be seen. I think that the value of these programs, you know, are still, you know, the wind isn't taken out of the sails in terms of the need for, you know, the programs we're talking about today. I mean, you know, the Lot Network's membership and you know, colleagues at other operating companies are still, you know, buried in you know, in these cases, and so you know, programs like Lot and like Unified, you know, will continue to be relevant for a long period of time. So that's it.
I was just going to say that I think the judicial reform around sanctions and I think is a really good move forward, and I'm really happy to see it. I do think it's going to have an impact in much the same way, philosophically speaking. The goals of Unified are aligned with that, which is we want to see the bar raised for NPEs. That is, if they're going to come and assert a patent in district court, they should do all the work necessary to make sure that those patents one, are of the highest quality, if the arguments they're making are valid, and they're not cutting corners and not doing the necessary due diligence to bring high-quality cases. And if they are, then, again, sanctions and other types of action taken against them won't be a problem. So I think it strikes a nice balance when you look at sanctions and attorney's fees, that it incentivizes the right behavior that we really want, while really making it a deterrent to engage in the kind of activity where you would have the possibility for sanctions and attorney's fees.
Let me finish up with one question. How do you, each of your organizations, see a lot of your members coming to you? Do you sort of actively outreach to those that you see that would be good members? Do you get members from networking by other members to those memberships? What's the most common sort of successful way for you to be expanding your membership?
We can start chronologically. I think we went through 6 years of our existence. The first 3 years were one phase, and it was relatively slow. 31 licensees in the first 3 years. Then we went to a period where we were doing 30 to 40 a quarter. And then we went to the next phase, which is really, I think, other entities like Unified, like Lot Program, and others that come after will have the benefit of the fact that we've done a lot of proselytization, a lot of one-on-ones, a lot of group activities. It's really a barnstorming activity, really raising consciousness and awareness of the basic problems, not only related to patent assertion entities, but corporate actors who are antithetical to the level of innovation that you get from open source activities and projects. And so we've had a broader aperture, if you will. The aperture is broader than it is just for looking at patent assertion entities. But it's been a period now in the last 15 months where we've gotten 500 licensees. And that the change is really about, it's gone from supply push to demand pull, because now there's a cultural shift in that people recognize that when you participate in these kinds of advanced global group collaborative development activities, as we all are, everyone is reliant on that because no one is operating independently any longer. Even Apple's iOS platform was an open source platform that they originally purchased, brought in, and closed up. So it's energy really derived from the open source community. And so what we're seeing now is people understanding that for the opportunities that you get, there are obligations. And the obligations are that you're going to forbear litigation, that you're going to participate in a healthy and constructive way in the community. And that's why Lot's gaining good ground now, and why Unified's adding new projects, new technology areas to cover, because there's this groundswell that's coming up to basically support, we need to do something, is what we're hearing, more so than what do you have to tell me? And so people are coming to us and saying, we want to fashion a solution, we want to be part of a solution, rather than we want to kind of sit on the sidelines. So we're getting less fence sitting and more people who are putting up some measure of value, whether it's capital and or their patents and freedom of in the support of freedom of action. And I would hope that the benefits of the groundwork we've done, that these two projects will live in the slipstream of OIN and have much faster uptake.
Well, I actually can say that that's actually true, very much that we are doing that. There's a consensus out there that OIN, organizations like RPX and AST, they've all laid a groundwork, and now companies are really much more comfortable with the notion that they can work with another group of companies, that everyone can kind of bear the cost and bear the burden of doing something together. And then it's just a question of which solution you use in order to get the results you want. I would argue that there's no one perfect solution. It's a combination of a bunch of different solutions that meet the goals you're trying to achieve as a company. Unified is in many ways got some similarities with OIN in that we are very zone or technology specific. We're not a general purpose solution, meaning if we work in cloud storage, if you've got cloud storage products and services, you very well might want to participate, but if you have none, well then we we'd love to have you participate anyway, but you're not likely to pay us if we're not going to do anything that protects the technology that you use. We have other technologies that are working, and what we end up in many ways doing to get to the question, which is how do we get members? We talk to a lot of companies, and we find out what they tell us is the technology areas they're either have the most concern with, or the technology areas they're most heavily invested in going forward. Where do they want to look into the future and say that technology area would be great if there was reduced NPE activity and increased freedom to operate? And when we hear that from enough companies in a particular technology area, then we start saying, okay, great. Now we'll do that work for you and be proactive in a way that you couldn't do for yourself. And that's really been kind of the genesis of the technology areas that we're working in, is that there's a group of companies that really form a coalition of the willing. We want this area to be different than what we've done before, and we're willing to help protect that going forward. I'd say that's kind of the genesis of it that I think makes the most sense and is the most interesting from our perspective.
The LOT program was born out of an idea of a colleague of mine at Google, or at least this is how it started. And he published a survey on our website about the LOT program, or what the precursor to the LOT program, this idea of the spring license and some other programs like the Open Patent on Assertion Pledge and a few others. And so the LOT program was, by far the one that got the highest response from the dozens and dozens and dozens of companies that responded. And what we learned is that this idea wasn't a Google idea. It was kind of percolating with some other companies as well. And some of those companies that had the idea and hadn't acted on it, joined with us and helped formulate the program. And so what all that is kind of an introduction to when I talk to people about the LOT program in individual companies, it's almost universally, once they understand it, they like the idea. It's it's very, very positive support. Of course, there's a company here and a company there that's in a very monetization focus with respect to selling patents because of its business life cycle. But there's been a significant amount of interest, and so where our members are coming from are just companies that we that have kind of responded positively, kind of walk them through the agreement, and there's a little bit of an education curve, getting them up to speed on the agreement. And then also we're seeing a lot of interest around industry verticals, and so I think companies look a little bit to the right and to the left to see what others are doing, and so we've been kind of targeting just different verticals, or Kevin calls them technology zones, but in any event we see a lot of people kind of wandering over to the edge a little bit and considering the program. And so we're really, really optimistic about